Welcome to the Supreme Court, where we're hearing the appeal in the proceedings brought by the Financial Conduct Authority against a number of insurers. We're ready now to return to Mr. Simon Salzido, Queen's Counsel, who is making submissions on behalf of insurers named Argenta. Mr. Salzido.
My lord, thank you. Just before we broke for lunch, I was showing your lordships the phrase merely adjectival, which, as you know, is in the judgment, but I was showing it to you from the FCA's written case at B10394. I was making the submission that labelling the express definition of the peril as merely adjectival does not advance the argument. But it does reconfirm that what the FCA is asking the court to do is to rewrite the clause. And it also begs the obvious question, if the radius limit is merely adjectival, then what is the noun? Now, in the clause, we know what the noun is, it's any occurrence. But that doesn't assist the FCA's case, because to say within 25 miles is adjectival of any occurrence doesn't really say anything other than the words of the policy. What they seem to mean by using the phrase merely adjectival is actually that you should change the noun, and that the noun is not any occurrence, but that the noun should be something like any outbreak of a disease including an occurrence. But outbreak is not relevant in the wording at all. So when your lordship see this phrase merely adjectival, your lordship should bear in mind that what's really being hidden by it is actually an attempt to change the noun, not an attempt to say what is and isn't an adjective. My lords, the court below, of course, did purport or claim to be determining the intention of the parties in the traditional sense, but it nowhere formulated in relation to Argenta what exactly the intention of the parties was, and more importantly, on this point, the point about the jigsaw point, the court, I'm afraid, lost sight of the principle that the intention of the contracting parties is to be gathered primarily from the words of the contract and not from anything else. My lords, I move then to ground 5, separate concurrent causes. So this is the alternative argument of the FCA, which the court below described as less satisfactory, but said it would in any event accept if the first argument was not. And that is that each and every occurrence of COVID-19 was a concurrent proximate cause of all the government measures and public reactions that came after that occurrence. Now, my lords, we've dealt with this in our written case at B5148 from paragraphs 97 to 105, and I adopt all of those points. But in my remaining time, I'd like to develop just one point about this. The law on this point includes and perhaps almost starts in terms of express statement with a well-known statement of Mr. Justice Devlin in Hiscox and Continental Express, which was before the court below, although it's not itself in our bundles, but you can see it in Bundle G, tab 11, page 118, where at paragraph 53 of, I think, one of the skeleton arguments that was before the court below, there's a quotation from Mr. Justice Devlin in Hiscox and Continental Express, that where a breach of contract was one of two separate causes of loss, which were both cooperating and of equal efficacy, that would establish liability. And my lords, although other aspects of the decision in Hiscox have been questioned since, that particular dictum has been followed many times. As your lordships know, it was accepted by the Court of Appeal in Wayne Tank. And if we could quickly look at that, at Bundle F, tab 50, page 1055, in the judgment of Lord Denning, page 67C of the report, you can see that Lord Denning also talked of not one dominant cause, but two causes that were equal or nearly equal in their efficiency in bringing about the damage. My lords, at the foot of that page, just going over to the next page, Lord Denning again referred to the matter in a similar way. Their exemption is not taken away by the fact that there was another cause equally efficient, also operating to cause the loss. And your lordships can see in our bundle at page 1057, which is the next page on, that Lord Justice Cairns at the very top of the page also, well, in fact, sorry, if you start at the bottom of 1056, just starting at the bottom of 1056, Lord Cairns said, But for my part, I do not, sorry, Lord Justice Cairn said, for my part, I do not consider that the court should strain to find a dominant cause if, as here, there are two causes, both of which can properly be described as effective causes of the loss. Mr. Lecain recognised that if there were two causes which were approximately equal in effectiveness, then it is impossible to call one rather than the other the dominant cause. I should prefer to say that unless one cause is clearly more decisive than the other, it should be accepted there are two causes of the loss, and no attempt should be made to give one of them the quality of dominance. Similarly, in the Miss JJ, if your lordships would look at that, please, at E, tab 23, page 584, in the judgment of Lord Justice Lawton, on the right-hand side of that page 36 from the report, he refers to Wayne Tank and said in that case there were two causes of a fire. The court adjudged the dominant cause came within the exception. All three members of the court, however, considered what should happen when there were two causes which were of equal or nearly equal in their efficiency in bringing about the damage. That was the case being considered. Similarly, at E588, in the judgment of Lord Justice Slade, at the very top of this page, page 41 of the report, I therefore conclude that the loss in the present case is properly to be treated as having been proximately caused by a peril insured against, even though the faulty design may have been of equal efficiency in bringing about the damage. So, so what we have here is a series of statements of the law which have been treated as authoritative ever since, which suggest the following: that the process the court goes through is first to identify the efficacious or effective or proximate or substantial causes of the loss, of which there will normally be one, two, perhaps in a case that hasn't yet come to court, there could be three. And then the court will work out whether one of them is dominant, in which case it is the proximate cause, or if more than one of them are of approximately equal efficacy. And in that case, the well-known consequences for insurance, anyway, set out in Wayne Tank and the Miss JJ, take effect. Now, my lords, in this case, if you were to say that all of the hundreds of thousands of occurrences of COVID in the UK in the early months of 2020 were of equal efficacy, including the vast number that were never diagnosed and many of which had no symptoms whatsoever, so nobody knew they existed, that could only be on the basis that the causal potency of each one was approximately zero. Now, you might say, yes, 100,000 things all with approximately zero causal potency are of equal efficacy. But my lords, the problem with this argument is it turns the process on its head. The court does not start by saying there are millions of facts about the world which all contributed an infinitesimal amount to the final outcome and to the policyholder's loss. And since those all contributed an infinitesimally small causal amount, they're all of equal efficacy, and therefore they're all proximate causes. Of course, the court does not do that. Instead, the court starts, obviously with the assistance of the parties, by identifying from among the millions of facts about the world, the ones that are candidates to be proximate causes, the ones that are of sufficiently important causal effect to qualify. In the case of insurance, the key question is whether the insured peril is among those candidate proximate causes. If there's a dispute, the court then chooses from among those candidate proximate causes, and in some cases will say more than one is of equal efficacy. But the effect of the judgment below on this point is to say that there's an infinite number of infinitely small contributions, and that adds up to the whole. But anyone with a mathematical background will tell you that if you start dividing by zero or by infinitely small quantities, then your analysis will lead you to fallacious results. And the same is true of causation. My Lord Legate.
May I put a hypothetical case to you, Mr. Salcedo? Suppose that there is a bus standing at the edge of a cliff, and 20 people get together, and between them they push the bus over the cliff, leading to its destruction. And we can suppose that any one individual wouldn't nearly be strong enough on their own to push the bus over the cliff. Indeed, it would have taken 15 or 16 of them to do it. That also means that if you ask whether, if in relation to any one particular individual, whether that person hadn't taken part, would the bus still have been destroyed? The answer is yes. But might we not want to say in that example that each person's contribution was an equally effective cause of the loss?
Well, my lord, the final question, was it an equally effective cause? It may well be on your lordship's example, but that doesn't make it a proximate cause, because the question is what are the substantial causes? And in that case, it would depend what purpose you were asking the question for. I mean, to make it equivalent to an insurance context, you'd need to be saying that the bus had insurance against the possibility of passenger 1 destroying it, but no insurance against the other 19 doing so. Now, if that was the position, there would then have to be a factual inquiry as to what was the nature of the joining together of the 20 people in their decision to push the bus over the cliff, and what were the causes of that. Now, if the position is that passenger 1 was simply someone who went along, was overborne perhaps by the forceful personalities of some other passengers who decided that this was the thing to do, then it may well be that passenger 1's contribution was not a proximate cause of the loss. If passenger 1 was the ringleader, then it may be that theirs was. If your lordship is simply positing, well, as a matter of physical force, they all join together equally, then my submission is that's a totally unrealistic example, because this isn't a question in physics. This is a question in legal causation. And in legal causation, what matters is what caused it to happen. Now, as a question of physics, you've then got 20 exactly equal causes, and it may be that a physicist would say that they're all 20 are equally the cause, if that's the case. It may be a physicist could work out you needed 10. But in legal causation, the question is, was there some kind of joint effort? Was there a motive force? And if so, what was it and what caused it? So my submission is one can come up with logically possible physics examples, but in the law, one looks for the proximate causes. And in all the time of the development of the common law, as it's happened, I'm not sure there's ever been more than 2, and certainly not more than 3. I'm not saying it's impossible. I'm not saying it couldn't be 3 or 4. There's no reason to make a principled division in terms of number. But where there is a reason to take a principled division is in the order of inquiry, which is you've got to look for seriously effective causes and then choose your proximate cause or causes from among them. My lords, and the reason you have to do that is because if you use the analysis of the court below and just say you've got an infinite number of infinitely small causes, then you can prove effectively anything. And the certainty of contractual construction is set at naught. And in our submission, that is not the way to go. My lords, therefore, that ground should also be upheld in my respectful submission. Ground 6 is the Orient Express, which I leave to Mr. Keeley. My lords, can I assist your lordships any further?
Thank you very much, Mr. Salcedo. In that case, we can turn next, I think, to Mr. Keeley on behalf of MS Amlin.
My lord, yes, I'm Gavin Keeley and I act for MS Amlin. I shall be making submissions on the disease clauses in the Amlin contracts, on the relevance and application of the factual but-for causation test in those contracts and generally, and on behalf of insurers on Orient Express. Now, it's not my purpose to defend either Lord Hamlin or the Lord Legate in relation to the Orient Express. They can defend themselves much more adequately than ever I could, but nevertheless, I'm going to have an attempt which may or may not be successful. Our written case, my lords, is at B, divider 7, page 205, and it is commended to your lordships. Commended to your lordships mainly because I had no part in its writing, and therefore it's much better than anything that I can actually personally deliver. But it is very good. And so any gaps in my oral submissions, and there'll be lots of them, can be filled by looking at our written case. Now, in relation to the Orient Express, I'll come back to that towards the end of my submissions. But we say that the decision of Mr. Justice Hamlin, as then he was, if I can call him that, in Orient Express is relevant to 2 essential matters. First, the identification of the insured peril as distinct from the uninsured cause of the insured peril. And secondly, the existence, application and effect of the factual but-for causation test, both as a matter of contract, but more specifically as a matter of insurance contract law. It is also, as it happens, a decision on wide area damage. It is instructive in the present context of wide area disease, and we say that it was rightly decided both at, as it were, first instance by the arbitral tribunal and also on appeal by Mr. Justice Hamlin. Now, you've just heard Mr. Crane and Mr. Salzedo. We adopt their submissions. Whilst our clauses are not identical to those of QBE and Argenta, we say that upon proper analysis, the differences are not substantive. My lords, I'm going to be, unfortunately, a little tedious because I have to take you to the MSA disease clauses before I go into areas of law of factual causation. Now, there are two MSA disease clauses, MSA 1 and 2. They're materially identical, so I'm just going to focus initially on MSA 1. And your lordship will see MSA 1 in bundle C, divider 10. And the relevant page at which you should begin is 504. And one thing that you should bear in mind while I take your lordships through the, as it were, preambular parts of this contract is that the causal connector in my client's disease clause is the word following. So when I emphasize the word following, you'll know why I'm placing emphasis on it. And if I emphasize another causal connector, you will probably be able to deduce why I'm placing emphasis on that other causal connector. But the welcome page is at C10 504. If you have it in front of your lordships, it is part of the contract. It is not just a welcome page, rather like a sort of an invitation or just say, hello, it's nice to see you. It is actually part of the contract. You'll see that from the second paragraph. This document, any endorsement certificates and the schedule must be read together as one contract as they form your policy. And in return for payment of the premium shown in the schedule, we agree to insure you against. First bullet point is loss or damage you sustain. In other words, physical damage. It's the material damage clause that your lordships find typical in these contracts. The second bullet point is loss resulting from interruption or interference with the business following damage. The third bullet point, not relevant, is legal liability you incur for accidents. That's the welcome page, and you'll see that it says following damage. Now, if you compare that, my lords, with the main business interruption insuring clause, which your lordships will see in the same document at page 560. And as I read this out, you'll recall the emphasis I placed on following damage. In the insuring clause, the draftsperson has said, this is business interruption optional section 6. For each item in the schedule, we will pay you for any interruption or interference with business resulting from damage to property used by you at the premises for the purposes of the business, occurring during the period of insurance caused by an insured cover and provided that damage is not excluded under section 1. Now, two things to be borne in mind when I read that out, they come to me. Firstly, of course, resulting from is equivalent to following. In other words, the draft person uses resulting from interchangeably with following. And my lords, whether that's as a matter of elegance of prose or whether it is deliberate, I know not, and nor do you, but it's quite clear that they are interchangeable. And secondly, and this is just a passing remark of no great significance, but your lordships may like to point it out, or I'll point it out to you, it says, provided that damage is not excluded. In other words, when the draftsman wants to use a proviso, the draftsman uses a proviso. When it says, provided that damage is not excluded, then that's the proviso that is employed. There was no such proviso in any of the disease clauses. You've heard from Mr. Crane and Mr. Salzedo on that, but the draftsperson in this contract could well have used the same proviso language if he or she had wanted. Definition of damage, because we've seen damage is emboldened, is way back at 512. So it's C divided 10 at 512. And damage there, my lords, is loss or destruction of or damage to the property insured as stated in the schedule. In other words, it's physical loss or damage as found by the court below, and we don't disagree with that at all. And then your lordships, I'm afraid to jump again, should go now to bundle C divided 10, same bundle, at 560. So just below the insuring clause that we've just looked at, we see, as it were, the second hole punch that your lordships may or may not have. You have claims basis of settlement A, gross profit. And it says the insurance by this item is limited to loss of gross profit not exceeding the limit of liability due to a reduction in turnover, etc. And then it says, and the amount payable will be 1, for reduction in turnover, the sum produced by applying the rate of gross profit to the amount by which the turnover during the indemnity period will, following the damage, in other words, that's the amount by which the turnover, by which the amount of the turnover will, following the damage, in other words, caused by the damage, fall short of the standard turnover. And then your lordships should know the definition of standard turnover, which is at page 559, that immediately preceding that on which I am. Standard turnover is defined as the turnover during that period in the 12 months immediately before the date of the damage, which corresponds with the indemnity period to which adjustments will be made as necessary to provide for the trend of the business and for variations in or other circumstances affecting the business had the damage not occurred, so that the figures adjusted represent as nearly as may be reasonably practicable the results which, but for the damage, would have been obtained during the relative period after the damage. So the but-for factual causation test is directly applicable to the standard turnover and to adjustments to be made. Now, these are very typical clauses. They're called trends clauses, standard turnover clauses. They're covered by my Lord, Mr. Justice Amlin, in Orient Express. They are typical of all the contracts with which your lordships are concerned, and indeed the way in which the court below treated the reference to damage in the context of the extensions to business interruption was to replace damage with insured peril, and we don't disagree with that at all. So in relation to the extensions, the business interruption extensions, it would read, affecting the business had the insured peril not occurred, so that the figures adjusted represent nearly as may be reasonably practicable the results which, but for the insured peril, would have been obtained during the relevant period after the operation of the insured peril. My lords, if you could now go to page 566, and I haven't even got to the disease clause yet, but if you go to 566, you will see the action of competent authorities. This is the beginning of the business interruption optional additional cover section, and it's provided as standard. So it comes with the policy, my lord. We will pay you for 1, action of competent authorities, loss resulting from interruption or interference with the business following action by the police or other competent local civil or military authority, following a danger or disturbance in the vicinity of the premises where access will be prevented, provided always, again, my lords, the draftsperson knows exactly what a proviso looks like and can even write it, provided always that there will be no liability under the additional cover for loss resulting from interruption of the business during the first 24 hours. My lords, there's a generous display there of the word following. Now, en passant, I mentioned that the court below correctly accepted that the word following in that clause meant caused, not some loose causal connection, rather, my lords, a direct causal connection. In other words, the business interruption must have been caused by the action of police, etc., and must have been caused by the action of police, etc., following a danger in the vicinity of the premises. So you can have a danger in the vicinity of the premises, which could be, in fact, outside the vicinity of the premises as well, but the court below considered that it was only the danger within the vicinity of the premises which was the necessary causal requirement. And your lordships see that, my lord, at the judgment at paragraph 437, which, if your lordships could turn to it, is in bundle C, divider 3, 155. My lords, I think Mr. Crane read 436. I'm going to read 437 to you. Even if there were a total closure of insured premises pursuant to the regulations, there could only be cover if the insured could demonstrate that it was the risk of COVID-19 in the vicinity, in that sense of the neighbourhood of the insured premises, as opposed to in the country as a whole, which led to the action of the government in imposing the regulations. It is highly unlikely that that could be demonstrated in any particular case. The narrow, localised nature of this cover means that the wider issues of causation and counterfactuals, such as we've discussed in relation to ARCH and EIO, that's ecclesiastical, my lords, wordings above, and such as we discussed earlier in the judgment in relation to the so-called disease clauses and hybrid clauses, do not arise. So the court there construed following as meaning caused by, and required that which was local, my lords, to be causative of the business interruption. And against that background, my lords, I now turn to the disease clause, which your lordships will find at page 567. That's C10 567, which is obviously the primary clause with which I'm concerned at this stage of my submissions. Now, your lordships see that clause, and as you cast your eyes down, you will see that apart from little a3, every insured peril there identified is something occurring at or from the premises. The exception is little a3. And it says consequential loss as a result of interruption of or interference with business carried on by you at the premises following little 3, any notifiable disease within a radius of 25 miles of the premises. Now, there's 4 specific components to which I wish to draw your attention. First, notifiable disease is not an abstract concept, it is a defined term. And the definition, my lords, you'll find back at page 559. It's not disease generally, as the court below appears to have thought. Just for your reference, my lords, paragraph 196, that's C divider 3, page 94. It is specifically, my lords, illness sustained by any person resulting from, little b, any human infectious or contagious disease, excluding AIDS, an outbreak of which the competent local authority has stipulated will be notified to them. Now, in doing that, I've actually missed out little a. That was actually deliberate, so I could emphasize now little a, because it is illness sustained by any person resulting from food or drink poisoning or any human infectious or contagious disease. But it is all preceded, my lords, by illness sustained by any person resulting from little a or little b. It is therefore specifically illness or illnesses sustained by persons resulting in our case from COVID-19. If a person sustains an illness, in other words, falls ill from disease, that in any normal sense is a form of occurrence or event. It is specific to that person. It is something that that person has sustained. It is something that that person has had, as it were, befallen upon him. It's not a state, it's not a situation, it's not a state of affairs, it's not the existence of something, it is actually someone sustaining illness. It is an event, it is an occurrence in all but name. So if your lordships take notifiable disease and the definition and you plug that in at page 567 to the notifiable disease clause, it reads as follows, my lords. Consequential loss as a result of interruption of or interference with the business carried on by you at the premises following illness sustained by any person resulting from any infectious or contagious disease, an outbreak of which the competent local authority has stipulated will be notified to them. That's the first component. The second component, my lord, that you have to bear in mind is that a boundary is set around the insured premises. The boundary is within a radius of 25 miles of the premises. So the cover is in respect of illness or illnesses sustained by persons resulting from food or drink poisoning or infectious disease, here COVID-19, within 25 miles of the insured premises. And my lords, within means inside, not outside the boundary. So what the parties have done is to have drawn a line. The insured takes the risk of illness outside the line, and the insurer takes the risk of illness within the line. It's as simple as that. That which is outside the line is uninsured, that which is inside the line is insured. Now, as we say in our case, which I've asked you to read later on, if you haven't already read it, that may be an arbitrary line, but it is a line. Third component, my lord, is the causal connector following. That, of course, and I'm going to come back to that and develop my submissions, that is a causal connector. There's no dispute between the parties, and the court below held that it was a causal connector, albeit a loose causal connector. That is a causal connector linking the 25 mild cases of COVID with the business interruption and the business interruption losses. And the fourth component, my lord, is to a degree superfluous and even, some would say, totally inapposite, but it's the meaning of consequential loss. Consequential loss, which is emboldened, is defined at page 512 of C10. And you'll ask yourselves, why is that fool Keeley taking us to this? Because I've just said it's perhaps superfluous and inapposite. But if your lordships look at consequential loss, there is some meaning or sense to my madness. It says, loss resulting from interruption or interruption of or interference with the business carried on by you at the premises in consequence of damage to property used by you at the premises for the purpose of the business. So we've got following damage, we've got resulting from damage, we've got in consequence of damage. All those, in the eyes of the draftsperson, and anyone reading this we would respectfully suggest, all those causal connectors are the same. They are all interchangeable. And the reason why, my lords, consequential loss might be regarded as a little inapposite is because if you plug consequential loss into the notifiable disease clause at C10 567, now I hate to read it out, but I have to, and your lordships will see why it makes little sense, because it says, we will pay you for loss resulting from interruption of or interference with the business carried on by you at the premises in consequence of damage to property used by you at the premises for the purpose of the business, as a result of interruption of or interference with the business carried on by you at the premises following any notifiable disease, which you might say makes little or no sense. But there is some sense. The idea of consequential loss being plugged in there, in conjunction with in consequence of damage, indicates that the draftsperson, whether not terribly well done or terribly ill done, was trying to convey the causative connections that we say exist between insured peril and business interruption and business interference, which we say is the loss. We endorse what Mr. Salcedo said before us. Now, I'm going to repeat something that one of my learned friends, probably both of them, said before me, and therefore you'll say, well, don't say it, but I'm going to say it nevertheless until you tell me to shut up, which is that those parts of clause 6 which talk about disease or other perils at the premises, the FCA has accepted, it seems, that following does not denote some loose causal connection, but rather, we would say, a tight causal connection, such that what occurs at the premises must be the source of, and so must have caused, the business interruption at the premises. Put another way, the FCA have accepted in relation, for example, my lords, to 6A1, that this is not a case of the insured being covered for business interruption at the premises resulting from notifiable disease everywhere in the country, provided that someone at the premises at some stage can be proved to have sustained disease there. And my lords, that you will see reflected at paragraph 194 of the FCA's Respondents case and 195, that's at B divided 10 394. Now, the FCA has not told us what it thinks is a correct answer to the interpretation of following in relation to those parts of the definition of notifiable disease which comprise illness sustained by any person resulting from food or drink poisoning. Must those illnesses have caused business interruption at the premises? Or is it sufficient for recovery that there should be business interruption at the premises as a result of food or drink poisoning anywhere in the country, provided that someone may be proved to have sustained similar food or drink poisoning at the premises? The answer to that is obviously not. It would be ludicrous to suggest that the food and drink poisoning at the premises should not have been directly causative of the business interruption. But that is part of the definition of notifiable disease, and one can imagine food or drink poisoning in the area of the premises, up to 25 miles, even possibly. I can't think of many instances, but it's not impossible. But it's quite clear in our respectful submission that when you have one causal connector following in one clause, one would expect it to mean the same thing in respect of little a, 1, 2, 3, b, c, and 4, not something different. And we would endorse the suggestions made by my learned friends before me, that following there, the implication of my learned friends' submissions, following there is a causal connector. It's not a loose causal connector. And we're going to tell your lordships in a moment that it means proximate cause, equivalent to resulting from or in consequence of. And we're also going to tell your lordships that it doesn't matter at the end of the day, even if it is a looser connecting cause, because we say that the factual causation test must apply. Once you have a cause, it's either a cause or it's not a cause. And therefore, by definition, if you have a cause, the but-for factual causation test must be satisfied. So after that rather terse introduction, my lord, the key question on the MSA disease clause is framed by the language of the contract. It is this: did illness or illnesses sustained by any person or persons resulting from COVID-19 within 25 miles of the insured premises cause business interruption or interference at those premises and the business interruption losses claimed by the insured? That question has two elements. The first, on which I've already made submissions, is illness sustained by any person resulting from COVID-19 within 25 miles of the insured premises. The second element, on which I've also made some submissions, is causation. Assuming that the insured can prove cases of illness within 25 miles, have those cases so operated as to satisfy the causal connection that has to be established between those cases and the business interruption losses for which the insured's claim and indemnity under the MSA policies. This second element, as you know, arises in the specific context of contracts of insurance. As my Lord Hodge said in McCann's Executors, your lordships will see that, I needn't take it out. It is at bundle E, divider 43, page 1196, which, is my Lord Hodge knows, is a Scottish case, but it's equally applicable in this instance to this country. As my Lord said, the context is important whenever questions of causation are being asked. That's paragraph 13 of my Lord's opinion, because it determines the nature of the causal investigation. Those are almost his words. As in this case, as in that case, so also in this. The relevant context is contracts of insurance, and more specifically, my lords, insuring clauses within those contracts. And if I can answer a question that my Lord Leggett asked a moment ago in relation to buses, or a bus, the causation question is not an abstract one as to cause. It is not what was the cause of the business interruption losses suffered at the insured premises. That is, with respect, the wrong question. Rather, it is, did the insured peril cause the business interruption losses at the insured premises within the meaning and application of the causal requirements of the insurance contracts? So, taking my Lord's example, a bus and 20 people pushing the bus, well, if only one person of those was an insured, or if only that person's efforts were insured, the question would be, did that one person cause the bus to go over the cliff? The answer to that, dare I say it, unless he was a Hercules, of Herculean proportions, and all the others were very, 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 very small and weak people. The answer to that is probably no, because that person cannot satisfy the factual causation requirement of but for. In other words, he cannot satisfy the factual cause test. But for that person's efforts, the bus would still have gone over the cliff. And that's the answer, in our respective submission, to my Lord Leggett's question. I hope that's the right answer. Anyway, that's my answer. We say that the causal connection that the insured has to prove between the 25-mile cases and the BI losses at insured premises is one of or akin to proximate cause. We say that based on the language and the law. But irrespective of that, as I've just indicated, the minimum causal connection that the insured has to prove is that the business interruption losses would not have been suffered but for those proved 25-mile cases of COVID-19. That, my lords, is the basic and fundamental factual causation test found in contract and in tort, with very few and very exceptional exceptions on which no party relies in this case. We say, as a matter of simplicity, X cannot in any sense be a cause of Y, whether proximate or not, if Y would have happened irrespective of X. In other words, but for X. My lord.
On that basis, Mr. Keeley, it means, in my example, none of the people caused the bus to go over the cliff.
And that's, my
lord,
lord,
equally be said of any individual that their efforts alone were not. So you embrace that conclusion, do you?
No, I just tell your lordship that your lordship's just asked the wrong question. If you are, say, a scientist, and you're asking the question, what caused the bus to go over the cliff? You would say it was the joint efforts of all 20. But that's not the right question. The scientist is not an insurance contract lawyer and is not looking at the right question. The right question is the question that I identified, which is that one person, if that one person is the insured, did he or she cause the bus to go over the cliff? And the answer to that is no, because but for that one person's effort, the bus would still have gone over the cliff. And therefore, dare I say it, and I don't mean to say it without respect, I'm saying it with the utmost respect, you've asked the wrong question. What caused business interruption losses at everybody's restaurant, say, in England? Well, it's the national lockdown or the public disinclination to go to restaurants because they don't want to die of COVID-19 or whatever it is. That is the scientist or the medical expert or the politician's question and the question and the answers. But if your lordship asks, did 25-mile radius cases of COVID-19 cause that restaurant to shut down? The answer is, and given by the court below, no. The answer given by the court below was different because of its approach to causation. But the answer, the right answer, is no, those cases didn't. You're not asking the right question if you say, what caused the restaurant to close down? You should be asking, did the insured peril cause the restaurant to close down? And that's the very important point that I made earlier, by reference to what Lord Hodge, my lord, said in McCann's. The context is important because it determines the nature of the causal investigation. In fact, my lord, it determines the question. It determines the causal investigation.
Mr. Keeley, at the risk of commanding your respect, even utmost respect again, I'm going to try another hypothetical on you, if I may.
That's a bit frightening, no.
This time it's the board of a company, and they decide at a company directors meeting to put on the market a dangerous product. And it only requires a majority of the board to vote for that, but in fact they unanimously vote for it. And one of them is insured under directors' liability insurance, and he makes a claim on the basis that his vote, which has subsequently incurred liability, let's say, and damages, was a cause of the dangerous product going on the market. Now, if you look at his vote in isolation, it would have made no difference if he voted the other way, because the decision would have been just the same. So it's not a but-for cause.
Wrong question, my lord.
On your analysis, he's uninsured, because it's not a proximate cause.
Wrong question. You're talking about a liability insurance, D&O liability insurance. If that director has been found liable, or his liability is established by judgment, settlement, or award, that is an insured peril that has arisen under the contract of insurance. And that is the proximate cause of the loss under the insurance policy, and he's entitled or she's entitled to be indemnified. So with the utmost respect, my lord, I would say that if you're looking at different types of contracts of insurance, you may have to ask different types of questions to come to the right answer.
Right, okay.
I'm sure your lordship's going to find a much more difficult question for me to answer in due course, which is why I'm going to rush to the end of my submissions before you've had the time. Now, the importance, my lords, of the causal investigation is heightened by the FCA's fundamental case that there is a single proximate cause of all losses suffered by all insureds under all wordings without distinction. You can look at it later. I'm going to tell your lordship what the FCA says. Particulars of claim, paragraph 53.1, that's at D, divider 16, 1582. The FCA says that the proximate cause of all losses is, quotes, the nationwide COVID-19 disease, including its local presence or manifestation, and the restrictions due to an emergency, danger, or threat to life due to the harm potentially caused by the disease. The FCA then refined its case a little bit. I don't actually think that it was much of a refinement. It looks like a slightly more generous approach. In its trial skeleton, that's the skeleton below, paragraph 225, bundle D, divider 20, page 1603, the FCA said, the definite article, the single proximate cause is the disease everywhere and the government and human responses to it. I need you to bear that in mind, my lords. We say that there's an obvious disconnect between what the FCA says is the proximate cause of all losses suffered by the insureds and what is insured under my singular Amlin disease clause. It is this disconnect which in our submission causes the FCA real problems, and it sought to surmount them in essentially two ways. First, as we've seen, it seeks to introduce the proximate cause of all the insured's BI losses into the insuring clause through the front door of construction by the use of what we say is an absent proviso. Secondly, it seeks to introduce the proximate cause of all the insured's BI losses into the counterfactual by the back door of causation, reversing not just the insured 25-mile cases of illness, but much more besides, including the underlying source or cause of those cases, in other words, the disease everywhere else. Now, neither of those attempts works, however, and that's because, my lords, what was covered were cases or incidents of illness sustained by individuals as a result of COVID-19 within 25 miles of insured premises, but those were not causative of any loss at those premises. Whilst what was causative was the national COVID-19 pandemic and the responses of the government and public to that national pandemic, but that was not covered. The FCA and the court below have, with respect, conflated what was covered but not causative with what was causative but not covered. And with that, I turn back to the definition of notifiable disease. We say that the insuring agreement was clearly confined to cases of specific illness sustained by specific persons as a result of COVID-19 within, and that means, my lords, not outside the boundary of 25 miles. It's a basic line. Can I ask your lordships in due course to focus on paragraphs 37 and 39 of our case, at the Amlin case, B divider 7219. The cases of illness beyond the boundary of 25 miles are simply irrelevant. The insuring agreement did not extend to any national or global epidemic or pandemic. That might be the cause of individual cases of illness within 25 miles, but it's not insured. It didn't extend to any national or global pandemic or epidemic, provided just one case of COVID-19 could be proved, perhaps years after the event, to have existed within the 25-mile radius. That is, my lords, a misconstruction of the policies. See paragraph 24.1 of our case at B7, page 213. And your lordship should know that if that had been the intention, my lord, then it was very easy to do. All one needed to do was say, following any notifiable disease, provided that there is a case of it within a radius of 25 miles of the insured premises, or following any notifiable disease anywhere, as from the date when the insured proves a case of notifiable disease within a radius of 25 miles of the insured premises to have occurred. That's what should have been in the clause in order to, as it were, maintain the FCA's construction, and that's nowhere near the clause. And my lord, I mean, one can imagine, we've taken, they say, extreme examples, but one can imagine how ridiculous this is. You have the Scilly Isles without a case of COVID-19 for months, but a trawler goes by, and on that trawler, someone contracts COVID-19, and it happens to be within 25 miles of the Scilly Isles, has no causative impact whatsoever. In fact, the person on board doesn't know that he or she has COVID-19, and when the trawler docks, say, at Southampton, that person is tested and is found to have had it for a week. Suddenly, every single business in the Scilly Isles, which has suffered business interruption losses as a result of the government's lockdown, can recover all their business interruption losses. Let's say that someone with COVID-19, I don't know who it could be, but with COVID-19 travels from London to Edinburgh. Anywhere within 25 miles of that railway line would suddenly be able to recover all their business interruption losses as a result of that one person travelling up on a railway line, 25 miles either side of the railway line, even though all their business interruption losses were actually attributable to the government lockdown. Further, my lords, any case of illness sustained by individuals as a result of COVID-19 within 25 miles of insured premises are simply not indivisible from cases of COVID-19 sustained by individuals beyond that boundary. Dare I say it, my lords, my illness is not your illness. My pathogen is not your pathogen. And they're not somehow rendered indivisible by virtue of deriving from the same virus or being part of the same global pandemic or national epidemic. These distinctions, that is to say between COVID-19 within 25 miles and COVID-19 outside 25 miles, are required to be drawn by the definition of notifiable disease and the 25-mile circumscription by radial distance of the insured premises. And that, my lord, with respect, dispatches the court's finding, judgment paragraph 111, at C divided 3, page 69, and at paragraph 532, C divided 3, page 179, and indeed the FCA's argument of indivisibility, such that the disease in the UK was somehow one indivisible cause of all business interruption losses, and therefore somehow or other the cases of disease within 25 miles of premises are harvested by some magical process into the epidemic or the pandemic. That just doesn't work as a matter of logic. My lords, I now turn briefly to the causal, well, actually not so briefly, but briefly to the causal connector of follow. Yes, my lord. My lord, Lord Briggs.
But expressions, and I'll, for this purpose, include indivisibility, have to be looked at in context. It may be that one wouldn't, you and I, if we each separately and on different days got COVID at different severities in different places, would think that they were thoroughly divisible in terms of their consequences and all sorts of other things. But whether it's divisible for the purposes of assessing what effect it had on the government action and the restrictions the government imposed, might lead to a very different conclusion, might it not?
Your lordship's absolutely right on that. But the way in which it was approached by the court below was, as I think one of my learned friends has already said, if one looks at the court below, the court below asked the question or set out the proposition, and I'll find it, if your lordship can just forgive me for 1 second. It was whether the insured could recover for business interruption losses at their premises, even, here it is, my lord, it's at paragraph 81 of the judgment, at C3, C divider 3, page 57. The court asked the question whether there is cover in respect of a pandemic where it cannot be said that the key matters which led to business interruption, and in particular the governmental measures, would not have happened even without the occurrence of COVID-19 within the specified radius. That's at C3, C divider 3, page 57. And we say that the answer to that question must be no. But your lordship is entirely right. It really does depend upon not only the facts, of course, as your lordship has postulated, but it really does depend, I go back to the point, which it depends on the context in which the question is asked, and in which case one has to ask the right question. Talking about following, my lord, following imports a causal connector. Everyone has agreed on that. In fact, one of its prominent dictionary synonyms include resultant, resulting, ensuing, consequent. See our case at footnote 15, B, divider 7, page 226. The FCA and the court held that following imports something looser than proximate cause, and we don't accept that. I've explained to you why. Following, my lord, firstly, I'll take this very briefly, is the causal link between the loss and the peril. We endorse what Mr. Salcedo said. We endorse not only what he said, but we say that where the clause says loss resulting from interruption or loss as a result of interruption following notifiable disease, the loss and the interruption are there, my lords, we say, part and parcel of the loss. In other words, the interruption is damage to the insured interest, and the loss is simply the pecuniary consequence of that damage to the insured interest. So we say that following is actually the causal link between the loss and the peril, and therefore the default position of importing a proximate cause test under Section 55 of the Marine Insurance Act 1906 applies. See paragraph 59 of our appellant's case, B divider 7, page 228. But as I've said before, these are not essential planks of our argument. The essential plank of our argument stands, regardless of whether the insured peril includes or doesn't include business interruption or interference, and regardless of whether following means proximate cause or some looser causal connection. The essential plank of our argument is that on its proper construction, the minimum causal connection that the insured has to prove is that the BI losses at the insured premises would not have been suffered but for the 25-mile cases of illness. That was rejected by the court below. The court below rejected the submission that the word following involved the application of any but-for test, despite emphasising and repeating that the word still involved a causal connection. The court below espoused a test of causation that seemingly does not accept the but-for principle. And the FCA, my lord, says that the but-for causation test is only relevant to quantification. And your lordships will see that in their case at a number of paragraphs, 11.4, 11.8, 31, 32, 33, 214, 355. It's only relevant to quantification, says the FCA, and not to the causal link between the disease and the interruption, or even to the link between the interruption and the loss. The FCA does not accept that but-for is an inherent part of or a necessary precursor to proximate cause. See their case at paragraphs 31 and 32. So a proximate cause can exist despite not satisfying the factual but-for test. That's the FCA's case. and it disputes, my lord, the application of the but-for test in causation, even outside the field of insurance. See the FCA's Respondents case at paragraph 374. The FCA also says that there is no insurance case which refers to the but-for test as part of or as a precursor to the proximate cause test. My lords, in our respectful submission, not only is that wrong, but again, it's answering the wrong question. The right question is whether there are any cases where something has been held to be a proximate cause, which is not a but-for cause. With the exception of cases of multiple wrongdoers and cases of exception such as the Fairchild enclave in the area of tort, which isn't a proximate cause case, the answer to that is no. With the exception of exceptional cases, we haven't found any authority that finds a proximate cause which does not satisfy the but-for test. Nor, it would seem, has the FCA, otherwise we would have received that authority from them. The but-for test, the factual causation test, this is important, is intrinsic to contracts and to contracts of insurance, because it is intrinsic to the essence of the insurer's indemnity obligation and to the insured's correlative right to an indemnity. Contracts of insurance are contracts of indemnity. They indemnify against loss caused by a peril insured against. If but for the peril, there would have been no loss, there is no indemnity. And I'm going to come back to that in a minute. But I want to start with the established legal background to the Amlin contract, i.e. the legal background, the legal context in which those contracts were entered into. Now, you know, I hope, and certainly I submit, that the law employs the but-for factual causation test as an undemanding, essential threshold test to distinguish causes from non-causes, necessary but not sufficient. As Sir Christopher Staunton said in Assicurazione Generale against Arrig, at paragraph 187, that's E, divider 9, page 161, in the context of inducement, causation cannot in law exist when even the but-for test is not satisfied. If the parties to the Amlin policies had wanted to indicate something non-causal, they could have used language such as connected with or relating to. They didn't. They used following, and that is a causal connector, and therefore the factual causation test has to be satisfied. That which is said to have followed an event must by definition be something that would not have followed but for that event. There is nothing in the policy wording we submit to indicate any intention to adopt some novel or bespoke concept of causation which doesn't entail the basic factual cause test, contrary to the court's judgment. Construing the MSA's disease clauses against the established legal background, we say it imports the but-for test. So, starting with the legal background, and I'll take this quite quickly and move to insurance contracts particularly. Whenever a legally relevant cause needs to be selected, such as proximate cause in insurance, the but-for test provides a range of candidates that satisfy the factual causation inquiry from which the legally relevant cause is to be selected. The but-for test of factual causation does not replace or supplant the test of legal causation. Now, that two-stage process was described by Lord Hobhouse in a case. Could I ask your lordships to take out bundle E, divider 35, and go to the case of Reeves and Commissioner of Police? That's bundle E, divider 35, at page 1005. I'm not going to take your lordships to many authorities because I know time is short, but I'm going to take your lordship to this and one or two others. At 1005, at letter C, B to C, Lord Hobhouse said, any disputed question of causation, factual or legal, will involve a number of factual events or conditions which satisfy the but-for test. A process of evaluation and selection has then to take place. It may, for example, be necessary to distinguish between what factually are necessary and sufficient causes. It may be necessary to distinguish between those conditions or events which merely provide the occasion or opportunity for a given consequence, and those which in the ordinary use of language would, independently of any imposed legal criterion, be said to have caused the relevant consequence. Now, certain causes will be discarded as insignificant, and one cause may be selected as the cause. It is at this stage that legal concepts may enter in, either in a way that is analogous to the factual assessment, as for proximate cause in insurance law, or in a more specifically legal manner, in the attribution of responsibility, bearing in mind responsibility may not be exclusive. In the law of tort, it's the attribution of responsibility to humans that is the relevant legal consideration. This but-for test also applies to the assessment of a liability to pay contractual damages at common law. The two-stage inquiry was described by my Lord Legate, with whom the other members of the Court of Appeal agreed, in a recent case called Minera Las Bambas against Glencore. You needn't take it out. I'm going to read out to your lordships the passage, unless the author wishes to look at his own words. It's at bundle G, divider 139 at 2405. And what the judge there said is as follows. The distinction between factual and legal causation is well recognised in assessing liability to pay damages at common law. In order to recover damages for a loss caused by a breach of contract or other actionable wrong, both tests must generally be satisfied. The test of factual causation is whether, but for the defendant's breach of contract, the loss would have occurred. This requires a simple factual comparison to be made between the claimant's actual financial position and the financial position which the claimant would have occupied if there had not been a breach. However, not every loss or gain which would not have occurred but for the breach is treated in law as caused by the breach, such that the defendant is held legally responsible for it. In particular, an unreasonable act or omission of the claimant without which a loss wouldn't have occurred may be held to break the chain of causation. Now, my lords, that's a classical, if I might respectfully suggest, established description of causation. Anyone agreeing a contract should, as a matter of factual context, be taken to have it in mind. And Lord Justice Legate's description, in fact, echoed that authoritatively stated by Lord Nichols in the tort of conversion case. I'll give you the reference, my lord. It's Kuwait Airways against Iraqi Airways. It's at E, divider 25, at pages 803 to 804. And that's a description by Lord Nichols. And he says, I take as my starting point the commonly accepted approach that the extent of a defendant's liability for the plaintiff's loss calls for a twofold inquiry. Whether the wrongful conduct causally contributed to the loss, and if it did, what is the extent of the loss for which the defendant ought to be held liable. The first of these inquiries, widely undertaken as a simple but-for test, is predominantly a factual inquiry. Now, as it happens, Lord Hoffman agreed with Lord Nichols. The FCA relies upon the extrajudicial writings of Lord Hoffman a few years later, in which Lord Hoffman says that the two-stage test is not recognised in English law. I suspect Lord Hoffman had overlooked his own involvement and agreement in Kuwait Airways that there was a two-stage process, but that's just by the way. The FCA's assertion that there is no established two-stage causation test is wrong. Importantly, as we're speaking in the context of insurance, the but-for test is also an established and essential component of any insurance contract. And this is important, my lords, because we say the FCA doesn't quite understand, we say with respect, the character of an insurance contract. It's a contract of indemnity. As my Lord Legate said in Endurance and Sartex, the insurer is under the contractual obligation to hold the insured harmless from loss caused by an insured peril, to prevent the indemnified person from suffering loss, that is, damn them. The insurer is automatically in breach of contract and liable in damages if an insured peril operates and causes the insured indemnifiable harm. The insured is therefore entitled to be put by the insurers into the position in which it would have been but for the breach, and no better and no worse. My lord, I won't repeat what you said in Endurance. It's at E, divider 37, page 1053. Your lordship said it's in different terms in Mineras Las Bambas at G, divider 139, at page 2395. And this is the important bit, my lord. If, but for the insured peril operating, the insured would have been in exactly the same position, then the insurer has not even breached its insurance obligations. There will have been nothing from which the insurer was bound to hold the insured harmless. There will have been no indemnifiable harm. Therefore, but for the insured peril, the insured would have suffered exactly the same harm, and therefore the breach of contract, or the putative breach of contract, will not even have occurred, because the insurer is only in breach if the insured suffers damnum as a result of the insured peril. If but for the insured peril, the insured would have suffered the same damnum, ergo the insured peril caused no indemnifiable harm, the insured was never in breach of any contract. And finally, in this context, I'll have to rush a bit, the but-for test is also an inherent part of the proximate cause test. An insured peril cannot even begin to be a proximate cause unless it is also a factual cause. That's clear, my lords, from the judgment of Lord Justice Lindley in the case of Reicher and Borwick. That's in F, divider 40, at page 829. If your lordships look, and I don't invite your lordships to do so now because of time, at 831 to 833, it's clear that a proximate cause is necessarily one that at a minimum is a but-for cause. And that appears from Lord Justice Lindley's judgment. It also, my lord, appears from my Lord Hodge's opinion in McCann, the case to which I referred earlier. I'll quote from Lord Hodge at E, divider 43, at page 1200, where my lord said, "It appears to me that in using the concept of proximate cause, the court in most circumstances applies not only a but-for test to establish a causal connection between two or more events on the particular occasion, but also further tests such as directness of effect and the degree of causal contribution of an event to identify an operative cause." That's at paragraph 12 of my Lord Hodge's opinion, cited with approval by Lord Clark in the Cos. That's E, divider 15, at page 298. It also happens to have been followed by Mr. Justice Hamlin, as then he was, in the Orient Express. So even where the insurance contractual language mandates a looser causal connection than proximate cause, such as by the use of the phrase attributable directly or indirectly to, the courts have held that at a minimum the but-for test must be applied. The Master of the Rolls, Lord Phillips, said in Blackburn Rovers and Avon Insurance, in an insurance case, disablement cannot be said to be attributable either directly or indirectly to a pre-existing condition unless, at the least, the condition is a causa sine qua non of the disablement. That's at E, divider 11, at page 195. And then there's one final point on but-for causation, my lords. The FCA refers to concurrent, interdependent, and so-called concurrent independent causes in its written case. Now, it's very important to bear in mind the differences between the two. Where the insured's loss is attributable to at least two causes in combination, in the sense that the loss would not have happened if only one of the causes had been operative, and each is a proximate cause, that situation is one of concurrent interdependent causes. In that situation, both causes satisfy the but-for test, precisely because the loss would not have happened if either one had not been operative. In that case, the law is that the insured can recover so long as one of the causes is insured and the other is not excluded. See Wayne Tank and the Miss JJ. F, divider 50, 1045, E, divider 23, 580. Wayne Tank and Miss JJ, and all the cases applying the principles established in those cases, including the B Atlantic, see Lord Max, that's at H, divider 3, at page 44, are all cases of inter independent causes. Each cause is both a but-for and also a proximate cause of the loss, as was recognised by my Lord Hamlin in Orient Express. By contrast, the phrase concurrent independent causes is used where there are two concurrent events, each of which would have been sufficient on its own to produce the entirety of the insured's loss, but neither of which was necessary. Concurrent independent causes do not satisfy the but-for test. See Lord Clerk in the Cost at paragraph 74, that's E divider 15298, and Mr. Justice Hamlin in the Orient Express at paragraph 32, that's E divider 31928. They are not, therefore, a cause in any relevant sense of the insured's loss. There are exceptions to that, my lords. The best known exception is that might arise where both concurrent independent causes are covered under one policy, but neither satisfies the but-for test on account of the other. Or, as you know in tort, where two people each separately shoots a bullet and each bullet kills someone. These are exceptions. That's not this case. So, my lord, I should mention that the FCA have come up with a new and unknown category of cause, which it calls an, quotes, intermediate category of interlinked concurrent causes. See the FCA Respondents case, paragraph 346 at B divided 10439. Now, whilst of course novelty is not something necessarily to be discouraged at law, it's not, this particular category is not known, so far as I'm aware, to the law, and dare I say it, is not very coherent in them. So, my lord, one applies the but-for test, and one asks the question that the court below asked, whether there's cover in respect of the pandemic, where it can't be said the key matters which led to business interruption, etc., wouldn't have happened even without the occurrence of COVID-19 within the specified radius. One answers that no, and that's the answer. I'm not going to mention any of the cases cited by my learned friends other than to say what they are, because neither of them is relevant. Silver Cloud and McGee, they're just not authorities of any relevant propositions for this case. So at the end of the day, my lords, while the FCA might be able to prove covered notifiable disease, it can't prove that it caused any covered BI loss. And while it might be able to prove what caused the BI loss, it can't prove that that cause was covered. And now I move to the counterfactual and Orient Express. The FCA says that even if insurers are right on the construction of the insuring clause, in other words, there is a radius of 25 miles, when you get to the stage of assessing the insured's indemnity and applying the but-for counterfactual, whether under the trends clause or otherwise, you reverse out not just the proved cases of disease within 25 miles, but disease everywhere. In other words, you reverse more than the insured peril. And it says that, my lords, in its respondents' case at paragraphs 11.4, 38, and 356. That's B/10, 338, 347, and 441. Now, that's not right. It's not even supported by the court below. Reversing only the insured peril indemnifies the insured for loss caused by the insured peril, no more and no less. Reversing more than the insured peril impermissibly expands the scope of the insuring clause and provides an indemnity for something that's not insured. Reversing less than the insured peril penalises the insured, and the FCA's justifications just don't stand up. It first asserts the inextricability of the disease within and outside the radius. I've already spoken about that. Secondly, it asserts that the counterfactual must be realistic, and a counterfactual which reverses disease only within the 25-mile radius is unrealistic. But the answer to that is given by Mr. Justice Hamlin in the Orient Express. The purpose of the counterfactual is to give effect to the indemnity principle, to reverse the insured peril. There's no rule that requires it to be realistic or not artificial. In fact, the FCA's own proposal that there's no COVID-19 anywhere in the UK, but it exists everywhere else in the globe, is as unrealistic and artificial as they come. Thirdly, the FCA repeats that it is impractical, even impossible, to assess insured's losses on the insurer's counterfactual. But there's no basis for that submission. There's no evidence. But in any event, it's dealt with, my lords, at paragraph 97.4 of our appellant's case at B/7 242, also paragraphs in the Hiscox appellant's case at 72 to 76, that's B, divider 6, 174 to 176. Anyway, I don't have time to deal with all this. If there are any difficulties of quantification, they simply have to be confronted, just as the arbitral panel did in the Orient Express, confronted as it was with difficult questions of assessment, where one had to assume that the hotel was undamaged, but the entire city was devastated. And I now turn to the Orient Express. You'll find that it's addressed in considerable detail, my lords, at our case B, divider 7, at pages 244 to 252. And I can do very little to improve on it. But, my lords, the facts are well known. Your lordships should go to the case itself, and I think the case is at E, divider 31, at page 921. Your lordships will forgive me, I'm just getting it out myself. The facts are well known, my lords. Katrina and Rita devastated New Orleans. The Windsor Court Hotel suffered significant physical damage. Its owner, Orient Express Hotels, had insurance against direct physical loss and damage, except as excluded. In other words, it had all risks physical damage cover. And it also had insurance against business interruption loss directly arising from such physical damage. The essential issue in that case was how the main business interruption insuring clause should respond, where the hurricanes had not only damaged the insured hotel, but had also devastated the wider area surrounding the hotel. If your lordships have that case in front of them, then you can turn to the policy and the terms at paragraphs 12 to 15. That's at page 923. The principal clauses of relevance are the following. The policy's insuring clause. In consideration of the insured paying the premium, insurers agree to indemnify the insured A under the material damage and machinery breakdown sections against direct physical loss, destruction or damage, except as excluded herein, i.e. this is all risks cover, to property as defined herein, such loss, destruction or damage being hereafter termed damage. So, my lords, damage was a defined term, and it meant loss, destruction or damage which was not excluded, i.e. in the context of that case, it was loss, destruction or damage as caused by an included peril, namely hurricanes. Then B, under the business interruption section, against loss due to interruption or interference with the business directly arising from damage, and as otherwise more specifically detailed herein. And 2, the insuring clause at the head of the business interruption section said, if any property owned, used or otherwise the responsibility of the insured for the purpose of or in the course of the business suffers damage as defined, etc., and the business be in consequence thereof interrupted or interfered with, the insurers will pay to the insured the amount of the loss resulting from such interruption in accordance with the provisions. Can I invite your lordships to read the trends clause, similar to our clause and similar to the clauses in all our policies, and your lordships will see the reference to, but for the damage towards the end of the trends clause. And when you've done that, if your lordships could read paragraphs 13, 14 and 15 and 16, you will see that there were 2 other clauses in the policy, the prevention of access clause and the loss of attraction clause, both of which responded to what had occurred and under which the insurer paid the required indemnity. Because both of those clauses are talking about property in the vicinity of the insured location, in other words, the hotel, being damaged. And as The learned judge said at paragraph 16, Orient Express Hotels has recovered an indemnity under the POA and LOA clauses, but this is subject to significantly lower limits than would be the case under the insuring clause. Now, my lords, the insured peril, for the purposes of the material damage section, was the fortuitous, non-excluded event or cause. On the facts, it was the hurricanes. If your lordships go back to the policy at paragraph 12, the agreement was to indemnify the insured against damage except as excluded herein. And under business interruption, the peril was different. The peril under the business interruption section was its loss due to interruption or interference with business directly arising from damage, as otherwise more specifically detailed herein. The insured peril was damage, and that is also reflected, as one would expect, in the trends clause, but for the damage. And if your lordships go to paragraph, I think it is paragraph 52 of the judgment at page 931, that's E31 931, to paragraph 52, in our respectful submission, the judge got it right, and the court below in this case got it wrong. Sixthly, OEH submits that the Generali's approach subverts first principles, in that it involves seeking to strip out from the claim for business interruption loss caused by insured damage not merely the concurrent consequences of extraneous circumstances, but the current consequences of the very peril that caused the damage, which was a proximate cause of the business interruption loss in the first place. In other words, OEH was submitting that you have to strip out the hurricanes and all the damage caused by the hurricanes everywhere in New Orleans. And that's what you need to strip out. But the learned judge said, however, the relevant insured peril, this is under BI, is the damage, not the cause of that damage. Similarly, in our case, my lords, we say that the relevant peril were the 25-mile radius cases of illness, not the cause of those cases of illness, not the pandemic outside. The non-excluded fortuitous cause, i.e. the hurricanes, were not themselves the peril under the BI section. They were the cause of the peril. They weren't irrelevant coverage, however, my lords. They identified and defined what physical damage was insured. It had to be physical damage caused by non-excluded fortuitous causes. But the perils under the property damage and under the business interruption section were not the same. The tribunal's award, quoted at paragraph 17 of the judgment at page 924. If your lordships look at paragraph 15, this is the tribunal of which my Lord Legate was a member. The issue arising on the construction of the policy is of fundamental importance to the approach to the business interruption claim has had a major effect on the nature and quality of the evidence adduced. Expressed in summary terms, the issue is this. Does the insuring clause of the policy provide cover, as OEH submits, for any and all losses suffered by the hotel as a result of the hurricanes and their effect, both on the city of New Orleans and in causing damage to the hotel? Or does it provide cover, as Generali submits, only for the losses caused by damage to the hotel itself, but not, save for the other extensions, losses caused by damage to and devastation of the city? If, for example, the consequence of the damage to the city but not to the hotel was a severe shortage of staff or a lack of demand for hotel accommodation, are those matters which Generali can deploy. And then, my lord, you have paragraph 17 of the award there quoted. And if your lordships go to the end of paragraph 18 of the award, that's at page 925, just above paragraph 19 of the award, the third question in Mr. Fletcher's formulation in opening submissions was, what is the loss resulting from interruption? It's the third question on which the parties part company. On behalf of Generali, Mr. Pickens, QC, submitted the words are clear. The cause of the loss has to be and be shown by OEH to be interruption or interference resulting from physical damage to the hotel and not from the damage to the city of New Orleans or, say, want of demand, etc. Mr. Fletcher did not, in the view of the tribunal, ever supply a convincing answer to this submission. He criticised the submission as one creating a false hypothesis because the cause of the damage to the city and to the hotel was the same event or events, and submitted that the policy was intended to cover losses resulting from all damage caused by the events which damaged the hotel, and only to exclude losses resulting from damage which was completely unconnected in the sense that it had an independent cause. He submitted the law relating to concurrent causes would in any event enable the hotel to recover in circumstances where a given loss was caused both by damage to the hotel and the damage to the city. And he submitted the effect of excluding losses resulting from damage to the city was to require an artificial and hypothetical inquiry to be made, very much like the submissions of the FCA in this case. To be made. But none of these submissions, in the view of the tribunal, address the language used in the provisions with which we've referred and which we've emphasised. The language requires OEH to establish that the cause of the loss claimed is the damage to the hotel. It's not necessary or relevant for this purpose to go behind the damage and consider whether the event which caused the damage also caused damage to other property. The fact that there was other damage which resulted from the same cause does not bring the consequences of such damage within the scope of cover. And my lords, the tribunal goes on to say that in any event, the language of the Friends Clause is conclusive of the subject. Now, my lords, that's exactly what we're doing in this case, this case, the FCA case. I want to move, my lords, to, if I may, to paragraph 20 of the judgment. Generally point out the answer to the question of law is moot. The tribunal hasn't excluded recovery of losses concurrently caused by damage to the hotel and damage to the vicinity of or consequent loss. It has only excluded losses which would have been suffered in any event, but for the damage to the hotel. Such losses are not to be regarded as caused in fact by the damage. At the hearing, it became apparent that the crucial issue of law dividing the parties was the appropriateness of applying the but-for causation test in this case. Now, in fact, my lords, I should mention that the court below criticised my lord, Lord Amlin, for not focusing on the proximate cause. It is, dare I say it, not surprising when OEH submits that this is one of those very occasional cases where fairness and reasonableness require a relaxation in the standard, and they referred to Kuwait. My lord, Lord Amlin, emphasised that the exceptions to the but-for test are pretty exceptional. Paragraph 74, he says that this may occur where more than one wrongdoer is involved. The classic example is where two persons independently search for the source of a gas leak. Similarly, my lords, if I could say in that case, if, for example, Orient Express, rather the insurers in Orient Express, had said, well, you haven't suffered a loss, a business interruption loss caused by damage, because that loss would have been sustained in any event. And when asked to indemnify under the POA or LOA clauses, the insurers would have said, or could have said, well, you haven't suffered a loss under those clauses because those clauses would have been suffered in any event as a result of damage to the hotel. The insurers in that instance would have been relying upon their own breach of contract in not preventing harm from occurring under the competing clauses. and you can't rely upon your own breach of contract to avoid your liability. So if they had been asked, please pay under the damage clause, business interruption caused by damage, they could have said, well, you'd have suffered loss in any event because of the devastation all around the hotel. And then if the insured had said, can you please indemnify in relation to the prevention of access or loss of attraction clause, the insurer couldn't have turned around and said, well, you haven't suffered any loss under that because of the damage to the hotel. And because the damage of the hotel caused you loss, the insurer would have been relying upon his own breach of contract in resisting liability under one or other of the clauses. In fact, Lord Amlin dealt with that under the rubric of absurdity, where he says you can't do that because it would be absurd to allow the insurer to rely upon another clause and not pay out under that other clause. My lords, I transgress and I've got very limited time. And what I need to do, my lords, to deal with this case better is just rush a little bit and go to paragraph 29 if I could. Although OEH cannot point to any insurance or indeed contract case in which it's been held to be inappropriate to apply the but-for test, it relies on a generally accepted principle that where there are two proximate causes of loss, an insured can recover on the basis that it is sufficient that one of the causes was the peril insured, provided the other cause was not excluded. There you see the Miss JJ. Whilst to date this has been a principle applied in respect of concurrent interdependent causes, OEH submits that it should be equally applied to concurrent independent causes. My lord, it wasn't, and rightly so, my lord. Those cases are not cases where one can recover because they are concurrent independent causes. And if your lordships go to the next paragraph, which I need to take your lordship to, it is, if your lordships could turn to paragraph 38, where the learned judge dealt with the fairness and reasonableness, and this is important. Thirdly, in any event, I'm not satisfied that it's been shown that fairness and reasonableness does require that the but-for test should not be applied. The tribunal, in accordance with the Trends Clause, has adopted a but-for the damage to the hotel causation test as the basis of assessing the recoverable losses. If such a test is not adopted, what is the alternative? One possibility would be but for the damage to the hotel and the city, i.e. an undamaged hotel in an undamaged city scenario. However, that would measure the gross operating profit, which would have been made by OEH if the hurricanes had not struck at all, and would therefore compensate OEH for all business interruption losses, howsoever caused, even where those losses were not in any way caused by damage, and as such are not recoverable under the main insuring clause of the policy. And that's exactly the answer to the FCA's case in this matter. It's not but for the 25-mile radius cases and COVID-19 everywhere else, which is what the FCA would like to say through some theory of indivisibility or proximate cause. It is but for the 25-mile radius cases. It's not but for the 25-mile radius cases and the cause of those cases, namely the epidemic or the pandemic, even extending to China. It is but for the 25-mile radius cases. You don't add anything in to that insured peril in order to expand the scope and extent of the indemnity. So, my lords, that is the effect of that case. And if your lordships could go to paragraph 46, this is the wording of the clause, the Trends Clause. As the wording of the clause, OEH submits that even on literal approach to the words, had the damage not occurred, or but for the damage, Hurricanes Katrina and Rita could not have occurred either. Hurricanes Katrina, Rita, which caused the damage, could not have occurred either. One cannot ignore the damage and yet pretend for the purposes of the trends clause that the event which caused the damage still happened. However, this doesn't follow. The only assumption required by the clause is that the damage has not occurred. It doesn't require any assumption to be made as to the causes of the damage. And then it says, secondly, OEH submits that the trends clause is dealing with the effects of real trends, variations or special circumstances, which either did affect the business or which would have affected the business had the damage not occurred. It's dealing with the implications of actual events, not imaginary or hypothetical ones. The only permitted counterfactual is to assume that there is no insured damage and to ask what consequences these actual trends, variations, or circumstances would have had. A hypothetical Rita or Katrina is not a special circumstance which would have affected the business had there been no damage, but an entirely fictional event. Those are the submissions of the hotel. However, the clause requires a single assumption to be made that there was no damage, and for the actual facts to be considered on the basis of that assumption, and that is what the tribunal has done. Similarly, in our case, doesn't matter how difficult it is, which it isn't, but it doesn't matter how difficult it is, one reverses for the counterfactual all of the insured peril, but no more than the insured peril. There is a single assumption to be made, which that there are no COVID-19 cases within 25 miles of the premises. And that's not an artificial assumption. The Scilly Isles survived for months without a COVID-19 case. Bits of Northumbria didn't have any COVID-19 cases at the beginning. Thirdly, it says, paragraph 48, OEH submits the opening part of the trends clause requires adjustments to be made for the trend of the business, etc. These words are looking at trends, variations, or circumstances independent of the insured damage. This is just the same as the FDA's case. However, the trends, variations, and circumstances considered by the tribunal were independent of the insured damage, albeit not independent of the cause of that damage. Similarly, in our case, you look at trends and circumstances independent of the 25-mile cases, but not independent of the cause of those 25-mile cases. Quite simply, my lords, if in that case the insured had wanted business interruption cover from hurricanes, it could have asked for business interruption cover from hurricanes. In other words, business interruption losses caused by hurricanes. That's not what it asked for, and that's not what it got. It got business interruption loss indemnity from damage, and that was all. Similarly, in our case, if I could take your lordship to, I've taken your lordship to paragraph 52, where we've got the insured peril, and then I want to go to 57 and 58, and then you'll be pleased to know that I have to be quiet, otherwise I'll be garroted by my fellow insurers. 57 at page 931, I agree with the tribunal that the clause, that's the trends clause, is concerned only with the damage, not with the causes of the damage. What is covered are business interruption losses caused by damage, not business interruption caused by damage or other damage which resulted from the same cause. Nowhere in the trends clause does it state that variations or special circumstances affecting the business either before or after the damage or which would have affected the business had the damage not occurred has to be something completely unconnected with the damage in the sense that it had an independent cause to the cause of the damage. The assumption required to be made under the trends clause is had the damage not occurred, not had the damage in whatever event that caused the damage not occurred. So 58, the learned judge says, I agree with Generali that OEH's construction effectively requires words to be read into the clause or for it to be redrafted. And then the last few lines, that is inconsistent with the causation requirements of the main insuring clause, which OEH accepts requires proof that the losses claimed were caused by damage to the hotel. Now, translating that into our case, I've already made a submission, and then I'll be quiet. Translating that into our case, my lord, that was a case of wide area damage. Our case is a case of wide area disease. That was a case of specific damage to a hotel. Our case is a case of supposed 25-mile COVID-19 cases. The only peril insured against in our case are COVID-19 cases within 25 miles. That's the only peril. If these insureds had wanted pandemic cover or epidemic cover on a national scale, then they didn't get it, and perhaps they could have if they had asked, I know not, but they didn't get it. And what the court below has done, and what the FCA seeks to achieve, is that the business interruption losses, which were caused by the national pandemic, should be recoverable by the insured, even though the insured peril was confined to COVID-19 cases within 25 miles of the premises. That was the deal that was made, and that's the bargain which has to be enforced by this court. As soon as you start messing around with things outside that perimeter or boundary, you are reverse engineering the contract of insurance, dare I say it, and you may be unduly, I'm sure you won't be, influenced by the circumstances that we are considering this issue in the light of what has occurred over the last 6 to 9 months. Whereas if you'd been asked this question a year ago, dare I say it, you would have had no hesitation in saying, this is a case where the insured peril is 25-mile radius cases. Have those caused business interruption losses? The fact that there is some disease outside is an irrelevance. You can't reverse engineer those cases either through construction or through causation into the insured peril. No, FCA or insureds, we're awfully sorry, but no. And those, my lords, are our submission. I'm sorry to have shouted at you rather a lot recently.
Thank you very much, Mr. Keeley. Well, we still have another quarter of an hour, so we'll turn next to, I think, Counsel for Royal and Son Alliance, Mr. David Turner, Queen's Counsel.
My Lords, as you know, RSA brings an appeal in respect of 2 of the policies which were under consideration at first instance. Taking them in the order in which I'm going to deal with them, the first is the cottage shore policy known as RSA 1, and that's a policy which is specifically designed for the owners of holiday cottages. That policy includes a hybrid clause with a 25-mile radius disease provision. I was going to deal with it second because it's a hybrid clause, but given the time, it's better to take it first because I'll be shorter on RSA 1. On RSA 3, the Eton Gate Commercial Combined Policy, that is a policy which contains, amongst other clauses, a 25-mile radius disease clause, as well as an exclusion, we say, in respect of epidemic. In terms of the points I'm going to make, beyond preliminary points, I'll deal, as I've indicated, with RSA 1 before RSA 3. Just in relation to causation, I should say that I adopt Mr. Keeley's submissions in relation to Part 4 causation and counterfactuals and the Orient Express, and I adopt whatever Mr. Crane and Mr. Salzedo before him said in relation to causation. I also adopt the submissions of Mr. Crane and Mr. Salzedo in relation to radius provisions generally, and I adopt prospectively Mr. Lockie's submissions in relation to pre-trigger losses. I also adopt the submissions of those who've gone before in relation to the significance of the words interruption or interference in the context of the insured peril, adopting, if I may, also the approach taken by my Lord, Lord Amlin, in the Orient Express case, where those words were not seen to be integral to the insured peril, but simply descriptive generally. One further point on causation. You've been taken to paragraph 112, 111 and 112, which deal with indivisibility and each occurrence being an effective cause of the national restrictions. Can I just draw your attention to paragraph 418 of the judgment, C tab 3, page 149. It's in the context of one of Hiscox's wordings, but this is where the divisional court seems to have provided a ruling which directly contradicted that which it had reached at paragraph 112, because in paragraph 418, the divisional court said it could not be said that any localized incident of the disease, that's an instance of disease at that point within a 1 mile radius, caused the imposition by the government of the national restrictions. And we say that that is correct, and the approach that should have been adopted in relation to the other policies. In relation to RSA 1, by way of summary, this is a policy which provides disease cover only as an adjunct to primary business interruption cover, which itself is parasitic on insured material damage to the insured's property. The policy only responds to the consequences of a notifiable disease either at the premises or within the specified radius of the premises. Disease outside the specified radius is not part of the insured peril. This policy does not include a trends clause, but it does include quantification machinery in the form of a definition which I will take you to, and the consequence is that the insured peril must be the sole cause of the loss. Could I take you then to the relevant policy terms? And they are to be found in Bundle C at tab 15 for those with tabs, starting at page 1114, treble 14. My lords, they are summarised in our written case, which I should also have said I adopted, B tab 9, and the summary starts in Appendix A at page 322 of Bundle B. There is a one document provision of the sort that Mr. Keeley took you to in relation to his wordings, which can be found on page treble 18 of the policy. It's the third paragraph down, so everything to be construed as one document. The following page sees the start of the property damage section. Business interruption insurance, the section starts at page 1125, and the insurance, the BI insurance, only applies where it is shown as included in the schedule. But I take you then to the schedule, and if we go to that at page 1195, schedule itself starts at page 1194. At 1195, in respect of business interruption insurance, what is insured is loss of gross revenue. And loss of gross revenue is itself a defined term. And we see the definition for that at page 1186. It's on the left-hand side of page 1186. It's the actual amount of the reduction in the gross revenue received by you during the indemnity period solely as a result of damage to buildings. So this is the provision I was referring to, which the learned judges said was part of the quantification machinery. And so I can knock this point on the head. In their judgment at paragraph 297, which is in file C, tab 3, at page 119, what they said is that the contractual quantification machinery, including the definition of loss of gross revenue, is intended to be applicable to heads of cover which do not involve physical damage and are to be read accordingly. So in other words, it was exactly the same manipulation of contractual language that they made in respect of the trends clauses, where the trends clauses provided for physical damage, and no distinction to be made about the manipulation of language, and no point arises on this appeal that manipulation should not be made in the context of RSA 1, or indeed in respect of any of the other wordings that your lordships are considering. The business interruption insuring clause back in bundle C, tab 15, at page 1135, in the right-hand column comes under a heading that would normally indicate that what's being discussed is a basis of settlement clause. But in fact, the heading itself is not particularly helpful because it's clearly setting out the insuring provision on the right-hand side. If damage by any event covered under this insurance occurs, etc., and causes interruption, we will pay the amount of the loss resulting from the interruption or interference caused by the damage. There is, as you would expect, a material damage proviso, which one finds on the following page in the right-hand column under the heading Material Damage Requirement. The key extensions are to be found at page 1129. So back in time, extensions to cover this insurance also covers one, failure of supply. So that's failure of supply effectively to the premises. Two is the disease, murder, suicide, vermin and pest provision, which is in terms that you will have encountered in the other policies that you have already seen. So loss as a result of, first, closure or restrictions placed on the premises as a result of notifiable human disease manifesting itself at the premises or within a radius of 25 miles of the premises, and then a series of other clauses which by now would be familiar to you. Injury or illness, closure of the whole or part of the premises by order of the public authority as a result of defects in drains or sanitary arrangements, murder, rape or suicide at the premises, closure or restrictions on the premises as a result of vermin and pests at the premises. Damage, as you would expect, is defined in the normal terms. I'll just give you the reference. It's see page 1184. Not ask you to turn it up, but it's accidental loss, destruction or damage. So dealing very quickly, if I may, with the scope of the peril and asking you to keep page 1129 open. For present purposes, only disease within 25 miles is relevant. And I adopt, with gratitude, everything that has been said before me in relation to that. Your lordships will see that what is covered is both disease or closure or restrictions as a result of a notifiable disease manifesting itself at the premises or within a radius of 25 miles of the premises. I adopt Mr. Crane's submissions in relation to the present participle. The suggestion that is implicit in the FCA's submissions, given their acceptance that the at the premises part of this peril applies solely to the consequences of disease at the premises rather than disease in the country, provided that it occurs at the premises. Plainly, the word manifesting cannot transform its meaning or form simply between the disease at the premises or the disease within the specified radius. There is no scope, we say, for syntactical distinction to be drawn between the 25-mile radius provision and the at the premises provision, and the FCA's concession in paragraph 194 therefore disposes of this particular point. In terms of the required causal link, which is that there be disease within the specified radius which leads to closure or restrictions which leads to loss, we say that those causal links are plainly causal links of proximate causation throughout. And that is the only sensible construction of the words as a result of. Certainly those words would not admit of any distinction to be drawn between section 55 and the statutory presumption of a requirement for proximate causation. And the FCA has effectively conceded the point, as you're aware, in paragraph 219 of its own case in response at bundle B, tab 10, page 401. They cannot have some looser causal link internally to the peril between the disease and the closure or restrictions than they have at the beginning of the clause, the link between the loss and the peril, because it would be fanciful to suggest that those words somehow change their meaning in the same clause. And I adopt Mr. Salcedo's submissions in relation to that. You already have my submissions in relation to the definition of loss of gross.
I just wanted to say that I've had a message from my solicitor saying I think the public link has gone silent. So
right,
the solicitors and junior counsel listening to this apparently may not be able to hear it on the public link.
And indeed, the transcript has stopped working as well, my lords. I'm
yes.
pretty well at the end. I probably need 30 more seconds, but given the link's gone down, can I ask for those 30 seconds to be tomorrow morning?
There are probably all sorts of reasons why that's a good idea, Mr. Turner. Very well then, we'll adjourn now and resume at 10:30 tomorrow morning. Thank you.
Thank you, my lord.